Hello, I'm Mark Granger. Today's podcast is brought to you by Pacific West Mortgage Fund, a full-service private money lender in the Los Angeles, Southern California area. Today's conversation is going to be on evictions, and we are honored today to have an expert in evictions, Sherry Lear, with Lear Law. She's in Torrance. We've worked with Sherry now for a long time. Let's just leave it at that. Decades. And she is outstanding when it comes to eviction. She knows everything about anything you want to know about this subject, Sherry knows about. So she's been very kind to come in and give us an hour of her time to talk about evictions, which unfortunately is something that we're starting to see more and more of in the marketplace. Not so much necessarily in single families, but certainly in some of the apartments and particularly in the commercial space, which the Granger Company does a lot of work in. So I also have joining me today my son, Patrick Granger, who does all our property management. And Patrick, I want you to jump in as well, because I know you've dealt with a lot of tenant issues and a lot of the commercial issues that we deal with tenants not paying or paying late or whatever. So
yeah, great to be here.
All right.
Thank you for having me.
It's, as I say, Sherry, it's an honor to have you here. So, okay. So let's start out with what's the difference? I hear this all the time. What's the difference between an eviction and an unlawful detainer for those of us sort of in the dark on this?
Well, there really isn't a difference. They're synonyms. Eviction is more the common language, and the statute that you're evicting tenants under is that they are unlawfully detaining the property. So hence it's in the courthouse called an unlawful detainer, but it's really the same thing.
Okay. Well, get that cleared up, because that is sometimes a confusion. Generally speaking, when can you start an eviction? Now, Sherry was making sure that we're clear on a lot of these questions, and I don't want to answer it for you before you do answer, but every one of these cities is pretty much different, particularly when it comes to residential tenants, correct? I mean, LA is different from Torrance, and they're handled differently.
Okay, so you're covering a lot by one question.
Right,
so
exactly.
Let me just kind of take a step back. So as far as residential properties, there is statewide rent control, which is the 2019 Tenant Protection Act, and that covers most properties with some exceptions, as long as you do what you're supposed to get the exception. So, for example, multifamily units are covered under statewide rent control, but a single-family home, if you've given notice that it's exempt, is not. Then underneath that, you have to look into the particular county. Different counties have their own rent control or just cause ordinances. Those are two different things. Rent control covers how much you can increase rent, and just cause ordinances cover what the causes are that you can use to evict someone. So Los Angeles County has some ordinances in place that apply to unincorporated areas of Los Angeles County. And then locally here in Los Angeles County, the biggest rent control it's called the Rent Stabilization Ordinance, or the RSO, covers the city of Los Angeles, but only properties built before 1977 or 78. I'm sorry if I don't have that exactly memorized in my head this moment. But if your property isn't under RSO and it's in the city of Los Angeles, it's under the JCO, the Just Cause Ordinance. So it takes a lot to keep track of all of these things. West Hollywood has rent control. Different cities have different rules, and you literally have to look at the property, figure out what city it is in, and which rules apply to it. So that's a kind of a starting point in terms of residential. In terms of commercial, it's much easier. So yeah. there aren't those kind of rules. There were some things in place during COVID, and those are essentially gone. Though things might come back because of the wildfires.
Yeah, I was just going to mention, not to get into the weeds here, but I understand from the that LA is considering some protections for commercial landlords that were affected by, for example, the Eaton fire or Palisades fire. I don't know if that's actually happened yet, but
I don't know if it's happened yet. I do know that they're already putting mortgage protections in place for people who can't make their mortgage because of the devastation of what happened in those fires.
Yeah.
There has been several motions in front of the Los Angeles City Council to stop rental increases and stop evictions for tenants who were affected by the fires. And it could literally change week to week.
It is changing week to week, for that matter. So generally speaking, when does a landlord, when do they start the eviction process from your experience?
Well, if you're talking about the eviction process as a lawsuit, the process actually starts before you file the lawsuit.
So why don't you go into that for a second? So
okay.
Here I am, Mr. Landlord, and I have a commercial tenant, so we'll make this example a little easier. The tenant stops paying. You call them up and say, hey, where's my rent check? And they say, well, go pound sand, we're not paying anymore. Then what happens?
Okay, so commercial evictions, in my mind, are easy because the leases generally that are very straightforward. If you're using an AIR lease, it's very pro-landlord.
Just to interject here.
Yes.
AIR is the American Industrial Real Estate Association lease. It's the most common lease in Southern California for commercial tenants.
So it'll be very clear as to what the tenant's obligations are. There are no reasons for a commercial tenant to be able to withhold the rent. And so that's a simple process. You give that tenant a 3-day notice to pay rent or quit.
Yep.
Please call me first or call your attorney and have them prepare the notice, because if you don't do it properly, then you'll have to do it again.
Thank you for bringing that up, Sherry.
Yes.
Audience, we have been down the road several times, and we see people in court that don't fill these things out, and they've waited months to get in front of a judge, and it's blown out of the water, or it's an expression, but the eviction is stopped and reset because they didn't fill the form out right. So,
yes, exactly. So you need to make sure that you're filling out the form properly, and then you need to make sure that the form is served properly.
There you go.
And that's how you start the process. And then the tenant will have 3 business days to pay the rent. And of course, I'm assuming right now that your commercial lease calls for rent to be paid in 3 days. It might say 5 days, it might say 10 days. So that's why I have to read the lease before I do the notice.
Right.
And once they don't pay, or in a commercial tenancy, they can actually pay part of the rent, and the landlord can accept it, and you can still move forward and evict them. So once that happens, that the notice expires and the default has not been what we call cured, then you can start the eviction process, which is called an unlawful detainer.
And how does that, walk us through okay, 3-day notice, they don't pay, they just ignore you. You go to the unlawful detainer. What's involved with that?
An unlawful detainer action is a summary civil proceeding in California. So it's not handled like a regular civil action. It's handled in a summary manner. So the time frames for the matter to be handled are accelerated greatly. Whereas a civil litigation might take 2 or 3 years, an unlawful detainer is designed to be resolved within 60 days. Now, that would be miraculous if that happened for all of them.
I was going to say, we don't see too many of those.
No, we don't. And so there are certain forms that you have to fill out that have required, language for an unlawful detainer. They're judicial counsel forms. So you need to make sure that they're filled out correctly. Again, please use an attorney to do this. Don't try to do it yourself. And you file the paperwork. The court gives the case a number, assigns it to a courtroom, and generally speaking, if you're filing for a case under $35,000, you're filing in a specific courthouse that handles unlawful detainers, and a specific courtroom where that courtroom handles unlawful detainers, so they're supposed to know what they're doing.
Right. So can I jump in for just a second? How many courthouses in LA County, for example, do unlawful detainers in the whole county?
I'd say it's less than 10. I was trying to figure that out before I got here because it does sort of change. For a minute, it was only 5, but they keep adding because of the volume of unlawful detainers.
How many of these cases are actually ending up in a court, though? I mean, I take it that obviously all of them are ending up in a court to be signed off or not by a judge, I suppose, but how many of these cases are actually ending up where you have a landlord and you have a tenant sort of arguing at each other? Or
Okay, I think what you're asking is how many do you actually end up going into a courtroom?
Sure, yeah.
Yes. That's a good question. I would say that probably over 50% of them, you end up actually showing up to court for a trial. And what is unique about an unlawful detainer case is that when you file what's called a memo to set, the case has to be set for trial within 20 days of that request. That's what makes it a summary proceeding. And you'll show up at an unlawful detainer court and they will be anywhere from 7 to 30 cases set for trial in that courtroom that same day. Maybe 2 of them will actually have a trial that day. The vast majority of them will be settled. So there isn't a lot of situations where the tenant and the landlord are arguing with each other in the court because, first of all, the judge wouldn't tolerate it. When you actually have the trial, if it's something very simple like a 3-day notice on a commercial tenancy, the whole trial itself maybe takes 15 minutes.
Right.
But you're there the whole morning. So well over 90% of the cases are going to settle on the morning of trial. And generally what that means, if we're going to be realistic, because I want landlords to really understand, is you give the tenant time to move out and you say, then I won't charge you any rent so you can get your property back, because that's the most efficient thing for you to do as opposed to dealing with, going to a trial or trying to get money from someone who doesn't have it.
Right.
So that's what happens a lot of the time. I've tried hundreds of unlawful detainer cases in my career. And, they can, like I said, they can last anywhere from 15 minutes to a few hours. It just depends on the circumstances. And it's a much more difficult process when you're dealing with a residential tenant than a commercial tenant.
Okay, I have 2 follow-up questions. The first is, in my experience in negotiating these things, Sherry, what we usually do is meet the tenant in the hallway and say, look, you're not paying the rent, you're not going to win this case, and we do something called I guess it's called a stipulated agreement. So
that's right.
So how does that work exactly? What is that? It's like an agreement between the parties before you get in front of the judge. Am I summarizing it correctly?
Well, in the statewide, they have a unlawful detainer stipulation form, but the County of Los Angeles has a more detailed form. So the form starts off with, judgment will be entered in favor of, and in this case, it's always going to be the landlord, and against the tenant. And from there, you go through the details of what you want the judgment to say. The judgment may include a monetary amount for unpaid rent, plus the rent that's come due since the lawsuit started, because once you start the eviction, you can't accept rent anymore.
Is that true for both commercial and residential?
Well, on a commercial tenancy, we're getting into some pretty technical details.
Yeah, right.
Let's just say you had a 3-day notice for $50,000, and the tenant made a partial payment for $10,000. As long as you do not accept more than what the amount is on the 3-day notice, your commercial eviction can proceed. In contrast, in a residential eviction, you cannot accept a dime once that 3-day notice expires, or you have to start all over again. And there are many times when I'm dealing with smaller landlords who need money. And so they'll take a partial payment and they'll dismiss their action and then start again. I don't want to fault anyone for doing that, but those are the kind of things that I have to talk about with my clients. Going back to the stipulation form, the stipulation there are many ways you can do it. You can have it that they do what's called a pay and stay, and if they make payments under a specified plan, then they're allowed to stay. And if they don't, then you can go back into court and say they didn't pay, we want them to leave. You can say they're just going to move out, and as long as they move out by this day, they don't owe us any money. But if they are late or they, trash the place, because I'm sure you've seen it, I've seen it, then they'll owe you money. And those are some of the options. Those are probably the most common options that you'll see.
Okay, follow-up question. So go out in the hallway, you talk to the tenant, he says, forget it, I'm not making any deals with you, I've never liked you, you've screwed me every chance you've gotten.
This happens a lot.
Has this happened to you before,
Is this a experience?
No. No, I'm an extremely kind and accommodating landlord, as you know. No, my question was, I have heard that one of the strategies now with tenants is they say, no, I want a jury trial. Is that
correct.
Something they can get in a unlawful detainer? Is that part of the program?
Well, we have something called the Constitution, and yes, you can always get a jury trial under the California or United States.
For an unlawful detainer.
Yes.
So does that jury trial have to be set within whatever it is, 20 days as well?
I have a jury trial set for March 17th right now. So yes, it will be set within the time period requested. Doesn't mean it'll necessarily start. There's a lot more work that you have to do for a jury trial. The court will require a lot more forms. You'll have to have a trial brief. You'll have to have jury instructions. You'll need to have witness lists, exhibit lists. It's a lot more formal. And also in this Los Angeles Superior Court, generally they will look at your trial notebook is what we call it, and they'll say, okay, it looks good, and then they'll send you down to Department 1 in downtown Los Angeles, and you'll sit in this giant empty courtroom, and Department 1 will take your books and say, we don't like them, you have to fix them and come back, or they'll say they look okay, and then they'll send you to a different courtroom. So those are some of the things in dealing with a jury trial. Plus that, you're asking your attorney to, take a week out of their life, and that's not going to be something that is inexpensive. And so it is, I use this term with my clients, it's like a legal blackmail.
Okay, so let me ask you the question, the devil's advocate here. Why doesn't every tenant ask for a jury trial? I mean, it delays things, it makes it much more expensive for the landlord. What's the downside for the tenant?
Most tenants who have an attorney do ask for a jury trial. In fact, I'd say almost all of them ask for a jury trial. Tenants who are defending themselves, sometimes they'll ask for a jury trial. But it is something that you're seeing more commonly requested by the tenants because there are self-help centers at each of the courts. And I do want to go back for a minute. I don't want to fault a tenant for asking for a jury trial. That's their right. But the discussion that I then have to have with my client is, what may have cost you X amount of dollars is now going to be 5 times that. And you may want to reconsider your position in terms of settlement. And so it's a way to, I don't consider it a way to delay because it usually forces the matter to a settlement. I have not had to take an unlawful detainer case to a jury trial because when I sit down and talk to my clients about the reality of what is involved, and you're going to be sitting in a courtroom for 3 days, and you're going to hope that you get, jurors who pay attention and believe you, then they realize, as a business decision, it's probably best that I settle.
Yeah.
So besides paying a whole lot more legal fees, do you see a lot of different outcomes from settlements versus actually going to a jury trial, or does it usually end up the same way? And sort of, in terms of what the landlord is getting out of it and what the tenant is getting out of it. I hope I phrased that question correctly.
Well, again, I haven't had to take an unlawful detainer case to a jury trial. I've definitely handled jury trials, but I've never had a landlord who's wanted to go through with a jury trial. Generally speaking, it is and the courts give you this sort of standard lecture when you come in. It's to both parties' interest to make a settlement because then you have control over what the outcome is. If the tenant goes to a trial and loses, they don't get an extra 30 days to move out. They don't get the chance to have their rent waived if they move out. they end up with a judgment that goes on their record and affects their credit and affects their ability to find a new rental unit. On the other hand, the landlord knows when the tenant's going to move out, has cooperated with the tenant, and can reasonably expect that the tenant will move out when they say they are and leave the premises in decent condition. So the difference is the differences are you may have a delay in getting the property back, but you are.
But it almost never actually gets there.
This is my opinion.
Yeah.
In the scheme of a business decision, are really not worth going through a jury trial.
For either party, it sounds like.
So
No.
I've got a question on this subject because I could see where this was going. My question is really. It sounds like the card that the tenant plays with the jury trial is really to force a better negotiated settlement. That's
100
really the game plan, right?
100%. And generally, what the tenant is looking for is X amount of days to move out. It can be anywhere from 30 days to 6 months. It's generally, I'd say, around 45 to 60 days, and to not owe any rent if they move out.
Exactly,
So they're looking to move out and to walk away from all their rental obligations.
I'm glad you answered that question that way, because I think that's really the question that landlords ask me is, how much, how long, and you just answered that in terms of what does the tenant want out of this arrangement. What they're looking for is time and some relief from the monetary damages.
Yeah, and let me just go step back a minute. In terms of a commercial eviction, no commercial tenant ever asks for a jury trial because those cases are easy. So, and plus that, we know that the commercial tenant has money to go after if they lose. But a residential tenant, if they can't pay their rent, they need time to find a new place, and they need to save up money to find a place to move into. Mm-hmm. And so that's the dilemma that they're facing in terms of life choices for them. So that's part of their motivation.
I'm so glad you brought that up, Sherry, because I think sometimes we get so emotionally involved in these cases, about how you're getting mistreated by the tenant and you've always mowed the lawn exactly on time and done everything you're supposed to do. But it's really important, landlords, to understand that there's two sides of this coin. A lot of times the tenant may be in this situation, something happens in their life and they're just not able to, and they need some breathing room. They effectively need you to let them off the mat to get back control. Losing your home is traumatic, or you're losing your apartment is a traumatic event. So I'm really glad you brought that up. I do have some follow-up questions for you. I read recently that one of the tools that landlords are using now is to leverage with tenants is to report these defaults and put them on their credit reports. They're showing that they're not paying their rent, and now the example I was reading in the Wall Street Journal was a case where somebody had like a 790 FICO score, and the landlord ratted them out, and then their FICO score dropped to 590 or something. And it really is there anything, I guess this is kind of off this topic here a little bit, but I don't think we've ever reported to a reporting agency like FICO or Equifax or any of those guys. Do any of your landlords do that?
Okay, so this is a Wall Street Journal article, so I'm not sure what states they're talking about.
Exactly, right.
Let me explain in California that unlawful detainer files are sealed for 90 days. And if the case is resolved against the tenant, meaning there's a judgment, then the file is open for public viewing. There has been in the past, and to be honest, I haven't really kept up with this, an outfit known as the UD Registry, which they'll literally send people to the court and they'll say, hey, give me all the open unlawful detainer files, and they will make the report against the tenant.
Interesting. Okay.
So the other thing is that if you get a judgment against a tenant, and I mean, I have drawers full of judgments for some of my clients, then we can record what's called an abstract of judgment. And I generally will do that almost always in a commercial situation where we have a judgment against an individual that we believe either has assets or at some point may acquire them. Once that's recorded, it shows up on title. So yeah, it can end up on your credit. And part of what you do at an unlawful detainer settlement, and we're kind of going back to the UD stipulation, is there's actually a form in Los Angeles County that seals the file permanently. So that even if the tenant agrees to pay you money, that the file is sealed and it cannot be viewed by the public.
Oftentimes, I assume that's what comes out in the stipulated agreement, that the opposing side, the tenant in this case, maybe says, "Look, I want this file sealed because I don't want these people reporting me to the agencies."
I would say it's 99.5% of the time.
Yeah,
and you can put a caveat in there that says, if you don't abide, we can go in and unseal the file, which means you'd have to make a motion to do so, which I have done, where people haven't honored their obligations, because that does happen for sure.
How are you finding the courts right now in terms of civil actions? Are you finding that they're just bogged down as usual, or are we seeing any light at the end of the tunnel in terms of, we're talking evictions right now, but I mean...
Are you asking evictions or civil actions generally,
kind
or
of both, really, but I'm just kind of the general feel for the court system now in LA. I know it's been, for a while there, it was just really, it took forever to have anything done. Is that still sort of the case now, do you think?
So we may have a difference of opinion on this because there was...
Okay, there you go.
Because there was a period where the court was putting very artificial limitations on how quickly a civil matter had to be litigated, and they were giving you 18 months to 2 years, which may not be realistic in terms of things, because technically in a civil matter, you have 5 years to litigate the matter and have it completed. So I personally am not finding that there are delays in terms of, you can always file an action. No one's going to stop you.
So an action is basically throwing up something new in the case, and it delays things, and people have to review it.
No, I mean it's just a lawsuit in general.
Oh, I see.
So how quickly that lawsuit proceeds really depends on what judge you're in front of and how they manage their calendar.
Really? There's that much difference, huh? Completely.
And I would say that what I'm seeing now is that it's taking well over a year to get a civil action, because I do more civil actions than I do unlawful detainers, except recently it seems like unlawful detainers every day.
Unlawful detainers have really increased, as I had mentioned to you.
Yeah, right. They are. But I do a lot of civil actions. And so we're not getting trial dates until 2026 now.
Wow.
But again, most of my cases are ultimately going to settle.
So they always settled, 2 days before the thing goes to trial, right? I mean, that's the game, right?
Part of the problem is that the courts have not they cut a lot of the fundings for the courts because, budget issues. And so we used to have court mandated arbitrations, used to have court, mediation programs. We're starting to see those come back.
Oh, that's interesting.
And I think that will be helpful in terms of resolving civil actions. They also now have people showing up at unlawful detainer trials to help you mediate your settlement with a tenant. I generally don't need to use that person because I can handle negotiations. And for our audience, you may have gotten flavor that there might be a little good cop, bad cop going on. I won't say who's who when I'm going with Mark.
So I wanted to ask you a quick question. You're talking about these mediators or a tenant or pro bono people that help tenants.
Oh, yeah.
Okay, so my question is, have you found that tenants, when they're getting advice from somebody like that, are more informed and more inclined to do a reasonable deal, or just the opposite?
So if you're talking about tenants that are represented by, say, a Legal Aid Foundation, or an outfit like BASTA, or outfits attorneys' offices that represent tenants, that's going to be a much harder negotiation, because that attorney is going to know every single nuance of the law, every single possible weakness with your case. be prepared to take the case to a jury trial, know how to take the case to a jury trial, know how to make their client be sympathetic. So in those cases, you are going to be in a situation where the landlord is not going to get a favorable deal like they might otherwise.
What about someone who's just got an attorney that's, and we're by the way, audience, we're really focused now on residential tenants. Commercial tenants are really a separate, it's just an easier process with commercial tenants, I've found.
Yeah, I find it much easier to handle commercial tenancies.
Okay. What are the biggest mistakes you see landlords make in these unlawful detainers?
Well, I'm going to backtrack again. The biggest mistakes I see landlords making is they're not updating their rental agreements. Every year, the state has more disclosures that you're required to make. And I can't tell you how many times I have had someone come into me with a residential lease on a California Association of Realtors form that they paid a real estate agent commissions to fill out, and they're renting a single-family residence, which is exempt from the Tenant Protection Act, but they didn't check the box. And I have to tell them.
That's an expensive mistake.
I have to tell you, guess what? You're now under the Tenant Protection Act because your realtor didn't check the box on the form that was created by CAR.
Right, yeah.
So the first thing I ask for landlords when they reach out to me on residential tenancies is send me a copy of your rental agreement and any amendments to it. And I would say probably going on 60% of the time now, it's like a whole new area of practice. I have to do a disclosure package, and we update the rental agreement. We make disclosures that are required. Mm-hmm. If it's a month-to-month tenancy, we may change some terms, and then we can do a notice to pay rent or quit or whatever the issue is. So the biggest mistake is that landlords don't update their lease, and the second biggest mistake is landlords try to do the forms on their own, and they do them wrong. And the third biggest...
Boy, I have seen that.
Yes.
Man.
The third biggest mistake is that the landlord says something which puts them into the realm of being considered retaliatory, which is...
No, we were in a webinar, we were watching a webinar last week or a couple weeks ago, and I remember it was like so comical. We were watching, they had this one slide come up, and I mean, it's all good information, no discredit to them, but it was this flow chart that was like...
What was that for?
I mean,
what was
it
that
was like an
chart?
organic chemistry class. It was like, truly, I mean, this is my job, and I could barely understand it. I mean, how you would do this as a landlord, through your Joe Schmo landlord, somebody that's not doing it as a professional, I don't know how you could even conceivably do that correctly. I mean, there's just no way.
Yeah.
You're just bound to make mistakes.
No, I was going to say, you don't have to come to me to get forms. There are good forms out there. The California Apartment Association has good forms. The CAR, California Association of Realtors, has residential lease forms. There's a couple things in there that I personally don't like. What I've done in my practice, because I have clients who, for whatever reason, may not want to pay a broker. And so I've culled from the different forms the mandatory language, and then from experience, my forms have additional language that addresses some of the common problems that my clients have seen, that I see.
Well, in your years of experience that you've run into. Yeah.
Right. And so I'm in the process of having to update and create a 2025 package because there were some new laws that got passed this year.
So I have a follow on these forms. I have a question for you. So the tenant signs a lease. They got all the addendums that they're supposed to be in there. They've worked through Sherry Lear, and it's just perfect. And then the new legislation comes in, or the new legislators come in, and they add on something new. So as the landlord, are you required to then send that form to the tenant, or? Because normally this legislation kicks in January 1st of each year. That seems like sort of the normal routine. But are you required to update stuff to these tenants or send them new forms?
The short answer is yes. And that's why I talked about doing notice of disclosures. So say, for example, that there's a new disclosure, like a few years ago, the flood disclosure came out. Then you just send the tenant notice of disclosure, and you add those disclosures in that language, and you just send it off to them.
What does the timeline look like on that? Like if the law comes into effect January 1st, they've been there for, whatever, 20 years. How long do you actually have to get them that flood disclosure?
The statutes don't actually state that specifically, but when a landlord comes, well, I could say some of them don't. When a landlord comes to me, that's, again, going back to earlier, I said I look and I make sure that they've made the required disclosures. There are some disclosures that need to be made in specific timeframes, and that was very, very prevalent during COVID. There were all kinds of forms that you had to serve during COVID. Right. Under the Tenant Protection Act of 2019, any rental agreement entered into after July of 2020 must include a disclosure if the property is not subject to the Tenant Protection Act. So if you have entered into a rental agreement after July of 2020 for a single-family home and you haven't made that disclosure, you're subject to that act.
Yeah.
But I haven't found a court that has said, oh, you made this disclosure in April, it doesn't count. But what you do see is if the disclosure hasn't been made, the court will say you don't have standing because you haven't made the disclosure. So I correct that issue first.
So just as soon as you reasonably can, I guess is the answer.
So that's a great point, because it's important to remember, folks, if you're running an apartment building and you've got a sharp attorney and so on, if you forget to send something out, don't just say, well, I'm going to stick my head in the sand. Go ahead and send out the form, right? That's the advice. And even if it's a little late, then at least you've made a goodwill effort on this.
I mean, I send out disclosure packages where I'm, doing disclosures that should have been made in
6 months ago or a year ago.
Years ago. And it's a mistake and you correct it. It's not the end of the world.
Right, exactly.
Unlike other things in unlawful detainers where if you don't have the exactly right language in your 3-day notice, it is the end of your case. Also, if you own an apartment complex and you're engaging a property management company, they should be aware of those forms and those updates and give you those forms and pass those out to all of your tenants. You shouldn't have to go to an attorney if you're engaging a professional property management company, in my opinion.
Yeah, and like the Granger company.
That's why you pay for a property management company. Money well spent, by the way.
Thank you for saying that, Sherry. I appreciate that, because that is very true. If you're hiring a professional, you should be getting that service, I think, is the answer.
Yes.
One quick question for you. A lot of landlords that I talk to, and these are generally mom and pops, and their tenant starts, twisting their tail, and they get wound up. Mm-hmm. And they go over and they're talking to me about, I'm going to go and turn that guy's power off, or I'm going to go turn that guy's water off, or I'm going to go and take his dog to the animal shelter, or some insane thing. That's a big no-no.
Okay, well, you probably saw my face on the camera, but if you turn someone's power off, that's a constructive eviction, because you've essentially denied them a place that's habitable to live in. And not only are you going to have to turn it back on, you're going to be fined for each day that you've done that. And then for 6 months, you're going to be in this realm of anything you as a landlord do will be deemed as retaliation.
Right.
So it is completely foolish. There is no such thing as self-help in California. You do have a summary proceeding to go through. It's not a perfect proceeding, okay, but it is there for you, and that's why when you have a difficult tenant, it's really important to get a property manager engaged or an attorney engaged, and then have those people or that professional handle the tenant communications.
And go see your psychiatrist if you're angry.
Well, part of what I do is people come to me and they have, tenants who are difficult or threaten them, who are violent. And I say, hey, I'll give them a 3-day notice and I'll tell them to bring the rent to my office.
Yes. Uh-huh.
And so that way the tenant doesn't interface with the landlord at all. And then if the tenant starts reaching out to the landlord says, you call Sherry Lear, because Sherry Lear can put her foot down and talk to the tenant and say this isn't acceptable.
So the message is get out of the loop. Don't get dragged into a fight with these tenants.
Yeah.
You're going to lose. In terms of, you're going to lose the high ground, the moral high ground is what I mean. If you start doing something with a tenant and screwing around with them, you're just going down the wrong path for sure when it comes to, if you're making life difficult for the tenant in any way,
it's always a mistake.
It's a huge mistake.
Always a mistake.
I always tell landlords that come to me, and they do often, about different scenarios. I say, remember, at the end of the day, at the end of this process, no matter how long it takes, you're either going to be in front of a judge, or you're going to be in front of a judge and a jury, and you better be able to explain your actions in a way that shows that you're a reasonable person, you've tried to work things out, you've done your best, you are being harmed financially, but effectively you're going through the normal legal process to resolve your claim. You're not going over and above that. And that seems to calm people down from my experience.
Yeah, that's good advice. As a practical matter, if you're in front of a judge, the actual process of the landlord testifying is very short. And you're basically answering yes and no questions. Did you rent to the tenant? Yes. Is this the lease? Yes. Did you sign this? Yes. Did the tenant pay the rent? No.
There was one other here that we were curious about, which had to do with handling abandoned property. So let's say you have a tenant that's, I would imagine this happens probably more with residential. I guess I don't really know. But let's say you all of a sudden just no contact from the tenant. They don't pay rent. You send a couple emails. You don't hear anything back. You go out to the property. Everything's gone. Is there any recourse there? Or is your best effort to just move on?
Okay, so you started to ask me a question about abandoned property, sort of morphed into something else. Let me just take this in two parts. The first part is going to be when a tenant literally abandons the property. And that's actually the easiest process to get your property back. If you have a tenant who hasn't paid rent for 14 days and you have a reasonable belief that they are not in the property, and that happens on commercial and residential side more than you would think, you give them a notice of belief of abandonment. All you have to do is mail it, and in 18 days you can come and change the locks. Now let's just say that you walk in there and you find that they left something behind, like a dresser or something. If the property on the residential side is worth less than $750, and on the commercial side, if it's worth less than $2,500 or 1 month's rent, after 15 days, you can throw it away. But you do have to give them a notice of right to reclaim,
right,
and list the property specifically. You don't get to just say furniture, clothes. You need to say 1 sofa, 1 table, 4 chairs. And the vast majority of the time, these people are never going to come back and get their things. But there are occasions where there is a house full of stuff, or there is, for example, a warehouse full of stuff.
Yes, we've been there. We have been there.
And in those cases, you would have an option to do a notice of a public auction. And
Really?
that is a process that I've had to go through a few times, almost always with a commercial tenant who's left behind, things of great value.
Right.
And that's that way. If you go through this public auction, the landlord is insulated from liability. It's not a fun process, but there really is no other process provided for in the California law for a landlord to handle valuable property that's left behind when the tenant does nothing to reclaim it.
So I'm really glad we're segueing into this because, okay, so fast forward, you serve the unlawful detainer, 3-day notice, go through it. The judge says, yeah, landlord, you're entitled. The tenant owes you, $150, and you walk out of the courthouse. Then what? The tenant's still in possession. You've won the case. Now what's the process?
The process is that you file an application for a writ of possession, and the writ is issued by the court. It takes a couple of days generally, And then you submit instructions to the sheriff who handles that particular property. So, for example, if it's Manhattan Beach, it probably goes out of the Torrance Civil Sheriff's Office. And you give them $180 and these 16 pages of instructions. And then the sheriff puts it in a pile. And as it comes up, they go out and they serve a 5-day notice to vacate. And if the tenant vacates in that time, great. If they don't, some point after the 5-day notice, and it could be day 8, it could be day 60 after the notice expires, they'll let you know we're coming out on this day and we're going to do a lockout. And they do them, I think, only in the mornings now, Monday through Friday, like between 7 a.m. and 12 p.m. And then you have to go out and meet the sheriff. And the sheriff...
With a locksmith.
Yes, with a locksmith. And you let the sheriff in, and if the tenant is there, and that does sometimes happen, the sheriff will say, you need to leave. And generally what the sheriff will tell you is that, you know, you can hang out with the tenant and give them a few hours to get their stuff out, because you really want them to get their things out.
Yeah, that's an important point, Sherry,
Yes.
that you don't want them leaving this piles and piles of stuff. How much time, assuming they do have a lot of stuff in there, how much time do they have? Did you already cover this? I didn't. If I did, I missed it. But how long do they have to get their personal possessions out of the house once they've been locked out?
For a lockout, it's 15 days.
Okay. And
you don't have to give them any sort of a notice that you've left A, B, C, D, and E. That is part of the benefit of having a sheriff do a lockout, that you don't have to go through that listing of all of the property that's been left behind.
Okay. That kind of important, because sometimes if you don't follow these rules exactly right, the tenant will come back and say, oh, you know, I had my grandmother's priceless jewelry in there, and what happened? Where is it? And you're like, what the hell?
I think we had a case like that.
I'm sure we have. So,
yes.
The other thing I wanted to mention, Sherry, and I did mention this to you, I think the last time we talked on in a professional manner, was there is a new regulation now, a new ordinance now, which is this AB 2424. It regards foreclosures, which gives tenants longer periods of time, and if they're in a foreclosure, they have longer time to sell the property. There's a whole procedural thing. Now, the reason I mention this is because this is just another example of these additional forms that are coming out that affect you. You really, if you're in the real estate business, either a lender, a property owner, you really have to stay on top of this stuff. It's just constantly changing. So,
an eviction for a foreclosure, after a foreclosure, generally is the person who's foreclosed upon doesn't move out. You don't even use the same forms in the court. You have to do a different kind of a pleading, and it has completely different rules. So you need to talk to an attorney about the situation and make sure that you are following the timelines that have been set out. And again, it's also a situation where the city of LA may have an additional rule, or
right, exactly.
give them additional time to cure their default.
Right.
A lot of these rules are being issued because we do have a huge homeless issue, and the government is trying to do what they can to keep people housed, but part of that is they're making it harder for landlords to do evictions even after foreclosure. And it's, there may be some good intentions behind it, but the problem is that for a lot of the landlords that I represent, who are small landlords, it's a huge monetary hardship.
Well,
on them.
Follow-up question: squatters. What happens? You have a house, you got the tenant evicted. 3 weeks later, you're getting ready to put a new tenant in. Your contractor goes out there to put in a new kitchen, and hey, who are these people? And then what?
That is a really difficult situation, because that person is legally a trespasser if they don't have any right to live there. And the police should tell that person to leave and trespass them, but they don't. They say, oh, you have a piece of mail that has your name on it, because these people know what they're doing, and therefore you have to go through the court system. So then what ends up happening is you have to come and talk to an attorney, and then you have to give this person a notice to vacate, which is typically, I would say, 30 days, because they're not a tenant. They don't have any, but you still have to give them a notice and give them time to get out. And then you actually have to evict someone who's trespassing in your property.
All over again.
This is not a story for entertainment value. This is a cautionary tale. I had a client who had a house and wasn't living there and went on, vacation. And while he was gone, someone moved into the house, started occupying it. And when he came and found them, they beat him up. And it was horrific. And then filed restraining orders against him.
Against the owner of the house.
It was absolutely horrific. And we had to go through an eviction. And after the tenant was evicted, the tenant took their couch outside on the front yard and sat on the couch on the sidewalk, and then continued to harass my client as he went in and out of the house. It was unbelievable.
Yeah.
So these kind of things do happen. They don't happen often. But, you need to secure your property after an eviction. You need to make sure that people you or someone else is going in and out of it regularly, so it's not noticeably vacant to someone. And this is also really true in industrial properties.
Yes,
when you have an industrial property or commercial property, these people will come in and they will scrape it for any piece of metal, anything that they can find. So what Mark generally does is he puts a security person in there, and they live there full time until you get a new tenant.
Yeah.
Because, you see everything in this business if you're in it long enough.
Yep. I was
just last year I was at showing a property. It was like 10:30 in the morning, and somebody, while I was there visiting the property with the landlord, somebody was in the building ripping the copper out of the building.
Yeah, exactly.
Yeah.
I can tell you, audience, that our policy at the Granger Company is we never leave a building empty ever. If the tenant moves out, either residential, there's a few exceptions to this rule, but generally speaking, if a tenant moves out, we have somebody that works for us temporarily live in that property. Yes. Because these horror stories of people moving in, the people that do this are experts at it, and they know exactly how to do it. If you're unfortunate enough to have one of these parties do this to you, it's one time and then never again, because it is horrendous. So just to recap, Sherry, first, make sure you have the right forms. Make sure the person that's filling the forms out knows what they're doing.
Yes.
Right? Don't cut corners when it's, you're thinking you're saving a few dollars trying to do this yourself or whatever. It's going to cost you in the end. Boy, we've seen that a million times. Make sure you're up to date on what you're doing, right? Don't be worried. How many times have you and I seen property where the lease was actually sold by, I don't know, Staples or something? This is not even, it's like
Yes. I still have clients who show up and they have a one-page lease, and I look at it, I go, this isn't adequate. And they go, I've been using it for 20 years. And I go, yeah, that's the problem. I evicted hundreds of people under these 1- and 2-page leases. That was before we got statewide rent control and all the disclosure rules. But
right.
It does not work anymore.
No more.
And you were not exaggerating when you said residential leases are 45 pages long. They are.
Yeah. And that goes for commercial leases too. It's not just residential leases, it's commercial too. So, Sherry, I want to really thank you for coming. Sherry works in Torrance. It's Lear Law. We've worked with Sherry now for 30 years. She has saved our bacon many, many, many times. And it's an honor to have you here and educating folks on what they need to do. If you do need to talk to Sherry, please go to our website. We have all her contact information. I strongly recommend using her in the right
you.
circumstances. I can tell you that if you don't use Sherry, please use someone, because you
Yes.
will be saving yourself a tremendous amount of headache and heartburn, or however you want to put it. Sherry, what I'd like to do is invite you to come back in a year or two and see what's
what's
changed,
happening.
what's changed, and what we can
Oh, my
expect.
goodness.
So thank you again so
Thank
much
you.
for coming.
Thank you.
Thank you.